My name is Wendy Berg. I'm an attorney at Community Legal Aid in Northampton. I represent victims of domestic violence in probate and family court in Franklin and Hampshire counties, in divorce, custody, paternity, child support actions, and sometimes in obtaining restraining orders. I've been practicing family law for over 20 years and am familiar with what my clients go through before, during, and after they leave their abusive relationships. Often my clients must leave their abusers quickly, taking their children to the residence of a friend or relative. Rarely are they able to stay permanently. Usually their host has children of their own, and there are not enough beds, certainly not enough bedrooms, to accommodate everyone. Often their friends or relatives are putting themselves at risk by taking them in, both in terms of safety, if the abuser knows where they are, but also in terms of the loss of their housing subsidies. In addition, agencies such as DCF frown upon children of different genders and ages sleeping in the same rooms. These accommodations are not and should not be considered permanent. My experience is that often my clients and their children will temporarily stay with a friend or relative for 1 to 3 months, but then are told to move out. At that point, they are in need of permanent shelter. According to the Housing Stabilization Notice 201207, Guidance of Verification to Domestic Violence, if a victim moves after 60 days, the verifications required to obtain emergency shelter will not be accepted because the date the victim produces the documents will not be within 60 days of the domestic violence incident. This puts the survivor in an impossible situation. The verifications requested to establish eligibility create additional burdens on domestic violence victims at a time when they are already struggling to leave their abusers. It is very difficult and terrifying for a victim of domestic violence to leave her abuser. Her safety is most at risk when she is in the process of leaving. She is concerned about how she will take care of her children financially and emotionally. She is concerned about leaving pets behind. She is concerned about being on her own and getting the necessary support to make a fresh start. She is not thinking about gathering the necessary documents for the purpose of establishing eligibility for shelter, nor should she be having to think about this. She should simply be thinking about getting herself and her children to safety. It is essential for homeless coordinators to accept survivors' self-declarations or their friends or relatives' declarations regarding their escape from DV. I'm getting close. Most DV does not take place in front of witnesses other than children, making it more difficult to obtain documentation from those who may have observed the DV. A victim often does not have medical documentation due to fear of revealing to a doctor how the injury was caused. Many of my clients have gone to the hospital after being abused and have been too afraid to tell the medical personnel what took place, particularly if the abuser is present, and he often is present. Some of my clients were never permitted to leave the house because the abuser monitored their every move, making it impossible to obtain such documentation. It is unsafe for a survivor to obtain any documentation if she is fleeing from out of state and does not want the batterer to know which state she is in. Often she may choose not to file any legal action due to fear of being found. I'm just going to summarize here. It may take months to obtain an appointment with a psychotherapist, another verification that could be used, and it may take weeks to hear back from a domestic violence specialist. Even meeting with a safe plan advocate and obtaining a restraining order may take days. Page 5 of 9 of the Guidance to the Homeless Coordinator, Provision 2, states that the applicant needs to show that she has pursued ways to prevent or avoid the current and pending or immediate pending homeless situation. I shudder to think what this means. A survivor of domestic violence should not have to show she did not contribute to the domestic violence. She cannot be expected to somehow confirm that she made efforts not to annoy the abuser. There should not be any expectation whatsoever that she should be taking responsibility for controlling or preventing the violence. The assumption should be that the batterer is controlling his own behaviors, not that the survivor caused him to batter her or could have prevented him from battering her. I understand that rarely are domestic violence survivors provided with presumptive placements, which would allow them to obtain the necessary verifications after being placed. This means that if the victim is still in the home of the batterer and not yet outside the home, she cannot obtain shelter. This prevents her from being able to leave the home. It exposes the victim and her children to more domestic violence, and the victim will also be taking the risk of having her children removed by DCF if they are exposed to additional domestic violence. I urge you to make the recommended changes. Wow.